Thanks, Gerard. That was quite cracking result for your client. I'm supposed to have a laptop, but while they sort that out, it's a bit unsettling sitting in front here because we've got a screen with a timer on, and all I'm thinking about is the pineapple ad, radio ad. I don't know if you've heard that. The guy never gets to say everything because time's up, and I feel I'm going to be in that position as well today. So please bear with us if we go slightly over time. So for us in our patent litigation section, we've had quite a busy couple of years. It started during COVID, and it just never stopped. Our caseload increased quite a lot, and we had quite a number of our cases that went to court in the last couple of years. So my intention is not to deal with any one of those cases in particular detail, but just to give everybody a bit of a feel on what type of matters do we deal with and what do we see. We're live. Right, so we represent Bayer in a couple of applications. Some of you might know Xarelto, the product. It is an anticoagulant. It's prescribed mainly when there was some surgery and you want to prevent thrombosis form. It also can be prescribed on a more general basis for people that need blood thinners with heart disease and those type of diseases. And it is highly effective. It is probably in South Africa currently on value, the best earning and the highest earning pharmaceutical. What happened in COVID is that it's not registered for any COVID relief, but a lot of physicians realized that quite early in COVID that the real problem with COVID is actually a thrombosis effect that it has in the body, and that's where a lot of other complications came from. And anybody at risk for any type of thrombosis, people were starting prescribing Xarelto essentially for that, just as a precaution for people in order to prevent thrombosis. So sales started fluctuating, and actually, if you looked at the sales in COVID, they followed very closely the curve that the incidence rates and death rates in the pandemic followed. So it's not just for that, but it had lots of sales during COVID. And during that period, two infringers launched generic products. The first was a company called Estelle, and they had a product called Xarelto that they brought onto the market. A couple of months later, Dr. Reddy's followed with rivaroxaban, and we launched urgent interim interdict proceedings, firstly against Estelle. That matter was reported. We launched in early February. By May, we had our first judgment, and they have been off the market since. We had a trial in that market against Estelle at the end of last year. Quite interesting. The trial, 2-week trial, foreign experts, quite a lot of evidence, difficult evidence. That trial was brought to court within a year. We're still waiting for the judgment. So unfortunately, sometimes we can get quick results on the interim side. We can get our trials and patent matters to court relatively quickly, but then you're often then in the hands of the judge. But in this case, the delay is of not big consequence because we've got an interim injunction in place or interdict. Same result with rivaroxaban, slightly different arguments, although we had a positive interim interdict against Estelle earlier. Dr. Reddy's continued to defend that interim interdict. Unfortunately for them, the same result. They've been off the market. There was an attempt to apply for leave to appeal. Normally, you are not entitled to get leave to appeal for a judgments which is not final. Dr. Reddy's tried to argue that the interim interdict is final in effect, but that leave to appeal was dismissed. And as we speak, our settlement in the Dr. Reddy's matter is being made in order of court. So they have settled with us, and they have agreed to stay off the market until the patent expires. So quite a nice result there. What was interesting here is that, unfortunately, some of the pharmaceutical distributors and pharmacies that had quite a lot of stock, especially of rivaroxared, refused to take the stock off the shelves and to stop distributing and selling. And the argument was that the judgment was against Dr. Reddy's in respect of the product, and that interim judgment is not against them. And because they've got the stock, they can sell it. And that was quite an interesting approach, which we haven't seen previously in these pharmaceutical cases. And Bayer, despite the fact that these distributors and pharmacy chains are some of their biggest retail outlets for their own products, took action, and we brought another application for interim interdict against the retailers, which was also successful. An interesting argument there from the retailer side was that, well, the matter's not urgent anymore because we took action against Dr. Reddy's, we were successful against them. And if we wanted to take action against the retailers, we should have brought our application at the same time. And counter argument was, well, we never expected you to continue selling in the face of a successful interim interdict against the company who imports and distributes the product. And your conduct created the urgency. Court accepted that and gave the interim interdicts. So in that matter, as I said, the main action against Dr. Reddy's is settled. We don't know what the position will be with the retailers. That's still going on, and we'll see how that develops. So, quite an interesting pharmaceutical case with lots of complexities. Different type of matter where we were acting for the defendant. For Microsoft in this matter, they were sued by what we call a non-practicing entity. So somebody in South Africa came up with an invention in 1998 that related to how data is downloaded for a program, for example, and the payment method behind it that sits in a different computer. And each time you open your new product that you bought and downloaded, there's a verification system that payment was made, which allows you access to the product. So if you think about it, that invention was made in 1998. So a long time ago. At that stage, everybody was still probably, some of us were still working with VHSs, and discs probably just came onto the market, so you could still buy your CD at Look and Listen, I think was one of them. But this is a long time ago. So, but this entity never put its invention into practice. And when Microsoft launched the payment system and download system for Microsoft 365, they got sued. Investigation showed that the patentee actually had a corresponding patent in the US and sued Apple and Sony in the US a couple of years earlier, but those matters were settled, which we assumed was a positive settlement for the patentee, but the patentee had no assets. And our investigation showed that there was a financial funder that was sitting behind the patentee, pushing money into the litigation, obviously in the hope of an early settlement, but there were no funds in the patentee that would have compensated Microsoft if Microsoft was successful. So we defended the matter on merit. There were good merits in the defense, and but also we brought applications for security of costs. Those were granted. There was a leave to appeal on that, which was also refused. We subsequently, the security wasn't put up because the entity didn't have the money, and the funders weren't prepared to put further money into the entity, applied for the case to be dismissed and for the patent to be revoked, and that matter was also settled earlier this year with no payments made and undertakings provided for Microsoft's clients. So positive outcome where in a patent matter, we used normal avenues through the legal system and the rules of court to stop, in essence, and this is the importance of this case, what is called in patent terms a patent troll, somebody that doesn't practice, got some rights, and waits for some big entity to come along and try and sue for harassment value and extract a settlement. But through the security of cost routes, that practice was stopped in this case, and it's something that in future we think will be used again. This is more mechanical, as some of the cases. This matter judgment at the end of last year, there were leave to appeal. That was dismissed or didn't go further during the course of this year. Interesting matter, these valves, I know everybody digs around in their own roofs, but if you go and check your geyser, each geyser's got 2 of these. It's pressure relief valve. It sits high above in your roof, above the geyser. If the geyser cools down, when water cools down, the volume of water becomes less and creates a negative suction on the system, which can, in some cases, cause the system, your water system, to collapse and break. And these valves are there to sit above the geyser, so if there's a negative pressure behind them, they open, the one-way valve, allows air into the system so that the system doesn't get damaged. When water pressure comes back, it closes and the system gets contained. So in this, there's a little one-way valve sitting in the middle, and what this invention was for is for a visual indication and a secondary valve which sits on top of the primary valve. So if the primary valve fails, what happens is this little closure device moves up, gets pushed up by the water inside this copper fitting, closes a secondary valve, and for a plumber, if they remove the green cap and they see the secondary valve sticking up, they know the primary valve has failed and needs replacement. So it gives a visual indication of a failure as well as a secondary valve. And the debate here, and this is the infringer's product, they had these little closure devices which acted the way that the patent said it should act when water comes into the cavity. It lifts, it seals, it gives a visual indication. But the patent wording was that this is a float. This closure device is a float. And the opposition argued that their closure device is not a float. Why? Well, we did experiments and we could show that, well, if you put this thing, this little device in this pipe of ours, and we raised the water level, it went up and it went down like it should, like a float does. But they said, no, if you throw it in a glass of water, it sinks. Well, that was interesting because on that argument, it's not a float and therefore no infringement. Our experiments then turned to this little hole that's at the bottom of the device. And we showed that, well, that traps air. So if it stays in the position that it's supposed to be in the valve, it stays upright, air is trapped, and that's why it's a float. They said that can't be because they calculated the density of their closure device. And on calculations, taking into consideration the size of the hole, the device is more dense than water. So it can't float because calculations show it shouldn't. Again, we just said, well, look at it. If it floats like a duck, if it quacks like a duck, it must be a floating duck. They came with a different argument. So no, it's not a float because what keeps it up there is the water tension, surface tension. That's why it's there, not because it's a float. And this argument came very late by the expert witness after we had closed our case. And he suddenly heated the water in an experiment that he did in court, and this device then dropped, because when you heat the water, you take away the surface tension of the water, and this thing sank. That was quite worrying for us, because it was quite a unique approach. And overnight, we ran experiments and realized that he was heating the water in his experiment to levels higher than what is normal in a geyser. So in cross-examination, we forced him to do the experiments again with specific water temperatures starting at 30 degrees, and we slowly went up. And we showed to the court that up to the temperatures that you would expect in a geyser, this thing floats. So at the end of the day, the court agrees with that, it's a float. So, you know, five-day trial, 2 days argument to decide whether closure is a float or not. Yeah, it happens. This one, also judgment earlier this year, quite an innovative idea. The inventor looked at a lot of car accidents where a car rolls, and I don't know this, but I haven't been in many car accidents, fortunately. But when a car rolls, the majority of the damage to the roof structure comes on the roof that hits the ground second. So in this car, it would have rolled, and as you can see, the one corner took a bit of a hit, but the opposite corner, the second corner, had the majority of the damage. And this was looked at, and the client realized that this is a problem that could be fixed. And the other thing is, all cars have got centers of mass. So depending on the center of mass of the car, where it sits in a roll, and the difference in distance from the center of the mass of the vehicle to the one corner, that, and the distance from that center of mass to the top of the roof, the bigger that distance is, the more damage happens on the opposite corner where the car would hit second. So the invention was essentially to change those angles and to create a roll bar, and specific angles, so that the distance between what the car would roll from corner to corner over its roof is reduced. And that was the patent claim, very much around the center of mass of the vehicle and the distances. And we had an infringer coming up with this product, was sued, interesting arguments in court. Things in patent court, often your most tense moments as a litigator and also for a client is when your expert testifies. In this case, the testimony on trial versus the testimony or what he said in consultation wasn't the same, which left us in a peculiar state. It proved a couple of things, but fortunately, there was enough pre-work and diagrams that were admitted and admissions that to be extracted from the opponents that we could argue the case based on those admissions, and the court found in our favor. But I think the important thing is here in our trial cases, evidence in these trials, always expert evidence, and you need to prepare your expert well. And there's a lot of pre-trial work that one needs to do in order to get the case in such a state that even if your expert starts making mistakes on the stand where you can't help him, that you've still got a fallback position, hopefully, on your papers. So the last case, my time is up, but I'm going to finish different from the pineapple guy. So this last case, interesting case, there was a prior judgment that placed a lot of or placed a patentees in the registration process for a patent, often in a very difficult position where if certain procedural steps were missed, patent rights could be lost completely. My colleague, Ramon Pereira, is dealing with this case in more detail in one of the breakaway sessions this afternoon. But we were fortunately able to overturn that earlier decision in this decision, which came out at the end of August, which I think makes the position for patentees a lot better, but Roman will explain it in more detail in his session. So thank you. That's the end of mine.